afternoon, good morning, depending on where exactly you are. So my name's Tim, I'm from Imagine Canada. Thanks so much for taking the time to join us today. Yeah, we're so glad to have you here. Today's session is presented by Tracy Iso, who you may have heard from already. She's from Intact Public Entities, and she's going to focus on the typical abuse claims that we see in the nonprofit segment and how legal decisions have evolved and continue to impact both the behavior, procedures, and outcomes of nonprofits and charities. So you'll be able to ask questions, get a better understanding of the importance of internal standards and policies that protect all stakeholders, firstly from potential abuse and harassment, but also to serve as an effective defense against the allegations made. So before we get started, we thought we'd take a minute to kind of share a little bit of the story of how these two organizations came together, so Imagine Canada and Intact Public Entities, which sort of came together last year. And we had these initial conversations that were very exciting and compelling because we realized that despite having very different kind of purposes and sort of positions within the sector, and then serving the sector, we had this strong overlap in terms of our goals for the sector. So yeah, we had these really exciting conversations that have sort of led to these series of webinars, but also towards our own our other work that we're doing together. So I'll hand it over to Sarah to kind of explain that dynamic and how that relationship was formed and kind of what we're doing together.
Thanks so much, Tim, and hello to everybody on the call today. So I'm Sarah, I'm the Strategic Planning and Partnership Manager here at Intact Public Entities. And as Tim said, when we started talking, we realized that there was some pretty clear alignment. At Intact Public Entities, our purpose is to help businesses and society prosper in good time and be resilient in bad times. And for us, that goes beyond the policy. A big part of that is supporting community service organizations like many of those on this call here today, so that they can keep doing the important work that they do. So naturally, the question became when we started talking, how could we work together to support that? One of the areas that really stood out was the Imagine Canada Standards Accreditation Program. From our perspective, organizations that achieve that accreditation are demonstrating strong governance and operational practices, things that are also point to a strong risk profile. So our risk management team conducted a thorough examination of the Imagine Canada Standards to see whether IPE could recognize this accreditation within our underwriting approach. And the answer was yes. From our perspective, organizations that achieve that accreditation are demonstrating strong governance and operational practices. Again, things that also point to a strong risk profile. And while that recognition provides preferred consideration and pricing, the bigger idea here is really about recognizing excellence and supporting nonprofits that are investing in strong governance and accountability. As part of that commitment to support, we're pleased to be here today partnering with Imagine Canada on this webinar series. And with that, I'm very pleased to introduce you to our Tracy Iso. Tracy Iso is the Risk Assessment and Solutions Specialist in the Risk Management Department here at Intact Public Entities. She has expertise in insurance claims, risk management, captive insurance, and climate change. She has over 20 years experience in the insurance industry. Tracy is an instructor for the Insurance Institute of Canada and has spoken at insurance conferences across the country and industry conferences as well. When Tracy is not on the road or teaching an insurance course, you'll find her writing articles on topics ranging from climate change to liability claims, volunteer risk management, and so much more. Her focus at Intact Public Entities is to research the risks that community service organizations, nonprofits, and municipalities across Canada are facing, develop ways to mitigate those hazards, and educate our clients in best practice solutions to create resilience in the face of an ever-changing risk landscape. And with that, I'm very pleased to pass it over to Tracy.
Thank you. Thank you, Sarah. Good morning to everyone, and a heartfelt thanks to Tim at Imagine Canada and my wonderful colleague and partner in crime, Sarah Silva. As Sarah mentioned, I'm in the risk management department at IPE, Intact Public Entities. So we're not just the big mothership Intact. We're a little bit different. We're our wholly owned little island of public entity insurance. My role in this company, what really sets IPE apart, I think, is that we have a standalone risk management department. And my role allows me to liaise with our expert claims department, and we do that a lot. Also, our panel lawyers. So we have lawyers that are, on a panel of approved lawyers that are specialists in their fields, as well as our own paralegals that we have on staff. And with all of that, we kind of synthesize that knowledge into practical solutions for our insured clients. And that's what today's presentation is. It's a synthesis of the lessons that we've learned in the trenches in claims, and that we've and the legal community at large. So I'm not going to talk about I'm not going to name names or anything like that today. So we're not going to say, this guy's doing this really badly. That's not what today is meant to be, but it is meant to show you where nonprofits sit in the legal landscape, and what to do when claims happen, and how important the standards that Imagine Canada have created can support you in those times when a claim happens. So I just want to read my notes to make sure I typically don't read off of notes, but I want to make sure that I'm not going to miss anything. And my colleague Marina, who's in the background kind of managing everything, will get mad at me if I don't do my housekeeping items. So before we get started, I wanted to let you know, I invite your questions. There's nothing, it's terrible. I'm a public speaker, but I hate the sound of my own voice. So if you have any questions, feel free to, there's a question right up here in the right-hand corner. There's a question mark. You can open that up and ask your questions there, and we'll try to field them during the presentation as they come in. I'm going to try to do that. But if there are too many, and I hope that there are, we could do a Q&A leave behind document and ship that all off to you for reference when we're done. So that's the leave behind. And then I hopefully will be able to field all of the questions in the 60 minutes I've been allotted. So we should be done at noon. Today's session is also being recorded. So for any colleagues you might have that might benefit from this session, we're going to send a link to the recording and you can share it. As a corollary to that, I'm just, because I'm in insurance, so of course I'm going to got to put my disclaimers in there. We're going to be talking about some past litigated claims a little bit and some cases, but everything I discuss here today is meant to be educational and informative, and I hope it is, but it doesn't in any way constitute legal or even insurance advice. It's important to remember that each audience member today, each amongst you, we've got a big group here today, so we're really grateful for that, but each one of you is going to have a unique claims exposure to abuse and other claims. And my goal today isn't going to be to solve all of the world's problems insofar as relates to nonprofit entities and abuse, but hopefully to get you to think perhaps differently and hopefully more proactively about those exposures. So that's really, there's my housekeeping. Marina can be happy that I did it, and we can move forward from there. Now, I would be, the other thing to remember in the audience, we're across Canada today, is that everybody's going to have distinct and different understandings of the way our legal system works. And if we can't really understand abuse claims, if we don't understand the way it's formulated. And I see we've got, do we have a question already? No questions yet. Okay, sorry, I saw a hand up. Okay, so I'm going to start with, and I'm going to thank Canada Justice for this structure. This is it. This is what the landscape that we live within. This is the Canadian judicial structure. At the very top is the Supreme Court of Canada. And then it goes down from there. But because we're not talking about military courts or taxes today, we're gonna get rid of that and just focus on what applies to us. We're gonna try to focus on civil courts and tribunals today, and they follow a hierarchy. So I should note that today we're gonna talk about civil law today and not criminal. And when we're talking about abuse claims, they can intersect and dovetail, or they can be intertwined. So we're going to touch on that a little bit, but for the most part, we're going to be focusing on a civil claim. And what that basically means is, and I kind of want to just make sure I'm not missing any notes, but for those of you that watch crime shows or legal shows, you know that a lot of research goes into past decisions. So if I'm addicted to them, so I'm always watching those crime shows that'll say, well, in this decision, Your Honor, this is what happened. And that's really how precedents are set. And that's super important that we understand that when legal counsel comes to a trial, they know how the decision is going to go based on past decisions. That's what happens in the common law. in Quebec, and I know we may have people here from Quebec today, they deal with the Civil Code of Quebec. So it's a little bit different, but the end result is very, very similar. So just to give you an idea of the way this hierarchy works, in 1999, the Supreme Court, so the highest court in the land, this right here, the highest court in the land decided on Baisley v. Curry that ostensibly an employer, so in our case, a nonprofit, and in that case as well, it was a nonprofit, could be vicariously liable for the wrongdoing of their employee. And in this case, sadly, it was sexual abuse. When they made that decision, they relied on a prior precedent-setting decision. And a lot of the times what will happen is a decision will be made and they'll create a test case. They'll say, this is what the test, it has to pass this test in order for this precedent to apply. And so they relied on the Salmon decision, in which the court created a test, like I say, whether vicarious liability will apply. So vicarious liability means right now, I'm responsible for my home and my dog and things like that. I'm liable for those things that I'm responsible for, but an employer, and in this case, a nonprofit, can also be responsible for the actions of their employees. As noted earlier, I'm no lawyer, but it's important from an insurance perspective, also from a compliance and nonprofit operational perspective, to understand how those decisions are made and establish how in your organization that can affect your day-to-day operations. So super important to understand that and why that's relevant. Because then when a claim comes in, and the other thing is that legislation also matters. So in 2016, the Limitations Act got a little bit thrown in the wind a little bit when it applied to sexual abuse. Sexual abuse, they said, there is not going to be any statute of limitations in that way. You can go back in history, and now we see those historical sexual abuse claims. That, as you can imagine, from an insurance perspective, but also as from an operational perspective, from a nonprofit, threw a lot of people into a loop, because it used to be, if you didn't make a claim within 2 years, unless you had really good reasons for that, you couldn't go back in time and make claims. So you can see how the word of the Supreme Court and those higher courts matter, but legislation, the courts look at that legislation and rely on that legislation for the be all and end all, and the statutes. So much the same as in Quebec, they rely on the civil codes to say, this is what the law says, and this is how the court must respond accordingly. So the important thing then is, when a claim happens, we need to understand that typically it'll go to a provincial or territorial administrative tribunal. So we could have an HRTO claim, for instance. We see a lot of abuse claims coming in there. Those claims tend to be on account of they're self-represented typically. Sometimes you'll see discrimination, but you'll also see abuse coming in through the HRTO. And then there tends not to be a huge roadway to appeal, but you can do it. And in the provincial and territorial courts, it starts with a lower court, and then you can go to an appellate court if whomever doesn't like the end decision, and then it goes up the chain to the Supreme Court, and then the Supreme Court gets to decide whether they're going to hear a particular case or not. If they think it has federal or nationwide relevance, they might hear a case, because they know when they set a decision, it's going to impact all of those other courts down below. And all of those lower courts will have to rely on what the Supreme Court is saying. So that's why that matters from a claims perspective, is we have to understand that if the Supreme Court or legislation says something, then all of those lower courts have to respond to it, and they have to follow in suit. So what happens when a claim is made? And before we can tackle insurance coverages that are going to protect you, we have to understand what happens when a claim happens, and what you should be doing from an operational perspective about that. So given the potential serious nature of abuse claims, complaints should always be noted and reported to your insurer. Now, that's much different than if you've got a broken downspout or an ice storm claim or what have you. You can tell that's a property claim, and so you might decide, because of your deductible, look, I'm not going to make a claim. It's not worth it. But when we're talking about abuse, especially if you've received a statement of claim or a notice letter, it's really important, because there are going to be some time restraints in there, that you report that claim to your insurer and get action on that right away. So then you might say, well, what's a complaint? Luckily, Imagine Canada has some standards for that, for what you should do when a complaint occurs. And again, I want to go over my notes just to make sure that I'm not missing anything. But when claims are brought by a complainant or a plaintiff, they're often, but not always, brought in the civil law landscape. Having a basic understanding of that legal system then is important. So there's also the criminal system. So if there's been a legal action against one of your employees or one of your volunteers, chances are there's going to be a civil claim that's going to follow up on that. So your insurer should be made aware of that. And again, that's different than a typical slip and fall claim where a plaintiff breaks their hip and sues the owner of a building for their injuries. For the most part, those claims will be heard in a civil court and not in criminal. So you can see how with abuse, and especially sexual abuse, there could be some involvement of both. So it's, instead of the Crown seeking a criminal indictment, the plaintiff is seeking reimbursement or a monetary award for their pain and suffering. That can also differ from the HRTO, where they can look for injunctive relief, where they're saying, look, we just want this to stop. We want this employee to be fired or what have you, because our civil rights have been violated or what have you. Typically, when we're looking at criminal, we're looking at punitive. They're trying to punish the wrongdoer. In a civil trial, you're looking at the tortfeasor, the wrongdoer, and you're trying to get the plaintiff to be reimbursed or made whole by what's happened to them because of the wrong that's been found. If you're at all confused about the difference between criminal and civil, one of the best examples that I always tell my students is go back and Google the O.J. Simpson trial. For those of you like me, that, like Sarah says, I've been in the industry for a really long time. So for those of you who remember the O.J. trial, that was one where the test for a criminal conviction is higher than in the civil. And so in the O.J. Simpson trial, the glove didn't fit, so they couldn't convict. And so what ended up happening is in the criminal trial, O.J. Simpson got off for murdering his wife and her friend. But the bar for a civil trial is lower. And so then the family of Nicole ended up suing O.J. Simpson for wrongful death. And in that case, the plaintiff won. So you can see how the civil, and even though that was American, the same kind of thing applies up here in Canada. The civil bar is lower than the criminal bar. And so you can see with sexual abuse, there can be a lot of intertwining of cases where they can cross over. For coverage for that, you could see legal expense coverage. It tends to not cover criminal applications because that wouldn't be in the good of the public. We do see some, albeit smaller, claims emanating from HRTO tribunals, especially in regards to cases involving discrimination, abuse of authority, and harassment. And there again, they tend to be smaller claims with self-represented complainants seeking retribution or injunctive relief. They want their job back. They want that wrongdoer to be fired or a cease and desist. So today we're going to focus on civil litigants, those plaintiffs who are bringing in action, again, typically in a civil trial for alleged abuse that they've sustained at the hands of or because of the defendant, typically a nonprofit and their employee. Remember, the plaintiff in these actions are typically seeking monetary rewards. That's the way they get made whole again. That might not seem fair, especially if you're the defendant or the insurer that's holding the purse strings, but that's the way the civil courts work. Typically in a civil trial, they're going to have a lawyer who more and more specialize in abuse claims. It's become a whole facet of litigation, and they actually seek out clients that feel they could have a case against a particular entity. As an example of that, we're seeing more and more plaintiff counsel who focus on class action lawsuits in response to maybe some of the recent court decisions against churches and organizations such as that. But nonprofits are not immune to that. So what happens when a claim is made? Typically when a claim is made against an entity, especially for abuse, it will come by way of a notice letter from plaintiff counsel. Typically, not always. So, and Imagine Canada has some great standards, and even if there's just rumors of, or if you know or ought to know is a pretty important bar for the courts, right? Even if you can't turn a blind eye to it and say, well, I had no way of knowing this was happening. If you ought to have known because you have all of your procedures in place, then you have to respond. So that notification is really important. When you get a notice letter or even a statement of claim, you need to act on it because the clock starts ticking for your response. And a little bit of a note before we move forward. I've received these from plaintiffs or from defendants in the past, and it's just gird your loins, because when you receive notice letters or statements of claim, they are meant to be antagonistic. They are meant to be inflammatory. They say some pretty terrible things, and your knee-jerk reaction from a human perspective is to get your back up and say, that's ridiculous, that didn't happen, or it couldn't have happened that way, and then ignore it. You do that, you're in for a world of hurt. So it's really important that when you receive that statement of claim, and nobody likes doing it, and it's always a bad day at the office when that happens, but I've read some of them that are so inflammatory, so derogatory, so and especially when it comes to abuse, they're just so terrible that you, from a defendant's perspective, they're not even believable. So it's really hard to look at that and take it seriously sometimes, and certainly not to be insulted. So you got to take a breath and do what you need to do, and make sure you're responding and notifying your insurer immediately. It's always scary, and it's hard, but you have to act professionally and responsibly and follow your procedure for complaints and incidents. Now, in some cases, it could be the first time the organization actually becomes aware of an issue at all. That it could happen that way. Typically, it doesn't, but it could be the first time. So before we can try to tackle insurance coverages for these things, it's important that we understand how the process goes. So once we get the notice letter, we notify our insurer, because it's abuse. We know we have to. It's not just a slip and fall, or it's not just a broken downspout. This is something that matters, and we have to report it to your insurer so your insurer can get to work. Typically, your claims experts are going to understand the timelines that are required for responding to a statement of claim or a notice letter, and typically will get a waiver of defense put in place so that they can work on the claim. So the claim is reported to the insurer. The first thing the insurer does, whether we like it or not, is establish insurance. We establish where the coverage lies. Now, from a person that's not in insurance, you might be thinking, yes, this is when they deny the claim because big bad insurance. But more often than not, especially with IPE, what we look for is which policy is going to respond. And that can really matter, because you've got different policies that might respond, and some might have more generous coverage than the other. Some might have a higher deductible, and some are more intended to what the allegations in the statement of claim are. And so it's really important from an adjuster's perspective or a claims examiner's perspective that we look at what the allegations are, or what they could be if we've only received a notice letter, what the formal allegations in the statement of claim are, and whether they're bogus or not. We have to say, okay, if they're true, what policy should respond? Should it be the one from 2023, or should it be this policy? And we're going to get into a little bit about which policy should respond in a minute. But really, we need to, that's the first thing that the claims examiner will do, is look at the coverage, and then we'll send out a letter typically to say this is the policy that's going to respond, and then our investigation begins. If a statement of claim has already been lodged, then typically what will happen is legal counsel will be assigned. And a lot of the times, one of the pain points we see is where we'll have a nonprofit that will already assign their own counsel. Maybe it's somebody that's sitting on the board and they're a lawyer or what have you. It's not something that we recommend, because abuse claims are very specialized. This isn't just your typical slip and fall claim, right? This isn't an occupier or premises liability loss. This requires expertise. And so typically and we also have agreed funding or not funding, but rates, etc. So we'll typically assign one of our panel approved lawyers, and that's an important thing. But the investigation will begin, which may involve an adjuster, etc., etc. And legal counsel is assigned. Then the first thing I can tell you that the adjuster will do, and even legal counsel will say, what are your procedures and processes? What do you have at your nonprofit for your complaints process? Have you stuck to it? What evidence of compliance do you have? That documentation is vital, and we're going to go over why in a minute. But ultimately, those procedures and processes are so important. And then we get into discoveries and pretrial mediation. The other reason why this matters is because this is the time when it's kind of like where it becomes a measuring stick. You've got to remember, when we're talking about litigation like a tennis court, if the plaintiff is on one side and the defendant is on the other, discoveries and pre-trial is really when the plaintiff counsel gets an idea about where his case is, where their case is. Is it a strong case or is it a weak case, and whether they're going to proceed or not. And so if you can walk in with banker's boxes full of procedures that you've followed, documentation that you've done this, be it timesheets or what have you, any kind of documentation at all, if you can walk into discoveries with evidence in that, it makes a huge difference when it comes to the plaintiff counsel looking at that going, oh, what are my odds of winning when we get to trial? Because remember, they know they've got a super sympathetic plaintiff that they can take to trial and a judge is going to like it, but not if at the same time the defendant is coming back with all sorts of really great evidence to show that they didn't breach their duty of care to that plaintiff. Okay, so with abuse, it's important to understand how important that your documentation is. So we're gonna move into a little bit about the complaints procedure and why it's so important that having an incident report or whistleblowing or complaint procedure is vital. And luckily, Imagine Canada has some really good guidance for that, and why it's so important that you're sticking to it. This is from Imagine Canada, that the organization has a complaints policy applicable to external stakeholders so that's for external, but to show internal as well, in a readily accessible location. So we're not trying to hide our whistleblower reporting. The organization responds promptly to complaints by external stakeholders. The organization informs the board at least once a year of the number, type, and disposition of the complaints. So that right there, there's a why you do this. This is super important. If we're not transparent with whistleblower or complaints procedures, if you try to kind of evade those things, that's the kind of thing a court will not look kindly upon. So that is really good guidance and super vital. Remember that in an adversarial, in adversarial litigation, documentation becomes proof that the organization had a policy and that they complied with it consistently. And that's, again, another piece of guidance from Imagine Canada to show that at minimum, this organization complies with employment laws, human rights, health and safety laws, and other applicable legislation. And that there's documentation that you do it, because when you get in front of a judge, if all you can say is, yes, Your Honor, we did that regularly, that's not going to be enough against a sympathetic plaintiff that's going to remember the day that happened. And I remember it like it was yesterday, and it's going to be able to detail it. And that's why that documentation becomes so important. Because if there's no documentation, courts will have a difficult time believing the right thing was done. Remember, you might have the best defense counsel in the world, but if you've got a plaintiff counsel that's painting a picture for the court, it's going to oftentimes, especially with the trends that we're seeing right now, go on the side of the plaintiff. No good deed goes unpunished. So for nonprofits, and it's a terrible thing, but like you're doing the good work out there to help our communities, and I'm not trying to dissuade you from doing that, just to make sure that if you're doing that, but also complying with the Imagine Canada's guidance, it will go a long way to helping you out when a claim occurs. Okay, so what are the types of claims we're seeing? Right now, we see sexual abuse claims, especially when in 2016, when they changed the Limitations Act to include historical abuse cases, especially when it came to sexual abuse, the floodgates opened, right? Plaintiff counsel paid attention, and they started paying attention to the sexual abuse claims, and this sounds terrible, but how they could profit from it, because that's what plaintiff counsel is there. Or you could take the stance, it's because they were trying to help out plaintiffs that in some cases took decades to come around and make a claim against the defendant. But importantly, from a nonprofit perspective, it's also enabling sexual abuse. More and more claims that we're seeing, and court decisions that we're seeing, is that the entity, the church, the library, the school, enabled the sexual abuse by not complying with the standards that organizations like Imagine Canada have put in place. They're there for a reason. And so if you've enabled sexual abuse, then you're responsible. You're more and more courts are finding you responsible even for that historical sexual abuse. Physical abuse, though, is still a thing. I mean, and that's sexual abuse is terrible, but physical abuse still is there. And that can be a litany of different allegations and things that are happening, but we're certainly seeing physical abuse claims coming through our nonprofits, including, and that physical abuse includes emotional abuse and mental anguish. And that needs to be dealt with in a proactive way. Again, when we're seeing those kind of claims, we're talking about using a trauma-informed approach when we're dealing with it. It can't just be back in my day, because again, I'm old, as Sarah has pointed out, I've been in this industry for a long time, that it used to just be in our day, toughen up, it's fine, you'll be fine, that doesn't hurt at all. And I'm the baby of 5 children, so it was like there was no, the favorite one was, I'll give you something to cry about. That was the way it was back in the 70s and 80s, I can assure you. But that's changed, and as a responsible nonprofit, we need to be aware of those changes and also be aware of how it's going to change in the future. So then we get into coverage, and I'm not going to talk about insurance. I don't sell insurance. I do risk management, but that risk transfer is a super important piece of your risk management responsibilities. We need to make sure that we're effectively transferring the risk away from your nonprofit organization and onto an insurance policy. That's what we want to see. Believe it or not, and this is an insurance person speaking, we want to see you effectively transfer it. We don't want to see you holding on to claims that you're going to have to self-represent on, because it's going to cost you significant amounts to defend it. And it may not, especially if you're relying on somebody who isn't an expert in that field, it may very well be that it's going to be defended improperly. And that can just make a potentially small claim even larger. So it's important that we understand that abuse policy, the abuse insurance coverage, and this isn't just IPE, this is across the board, across the industry. It's not boilerplate. And when I say that, I mean, it's not like your homeowner's policy. You could pull out your homeowner's policy right now, your homeowner's insurance policy, and you could compare it to your neighbor's homeowner's insurance policy, and chances are they're going to be really similar. Abuse insurance is not like that. It should be tailored to your organization. There's a much different insurance abuse policy in place for a school versus a kids camp or a foster agency or a shelter. All of those are going to need different coverages. So it's important that we understand you just don't go to your local brokerage and say, yeah, I'd like a liability policy, please. It's important that they're asking questions and that they understand what the risk is that they're transferring for you. Super important that we understand that. The good work that you people do on a day-to-day basis needs to be covered by a policy that's going to respond. But if you don't understand what your exposures are, and you may not be transferring them properly. And just a shameless plug here, our next presentation that we've got coming up at, when is it, Sarah, the end of in May, right?
May 7th, I believe, but we've
May
got
7th. Yeah, it'll be at the end, but in May, we're going to be talking about volunteer exposure, for example, right? Dealing with volunteers. And don't think for a minute that you're not exposed to abuse when you're talking about volunteers, right? Because your volunteers expose you to abuse as well. So even something like that, to think about, well, what's your volunteer workforce look like, is something that we need to be taking into consideration when we're talking about insurance coverage for volunteer organizations. And let's face it, most nonprofits are driven by a volunteer workforce. One thing that we talk about is the difference between occurrence-based and claims made. And I wasn't going to do this, but I am going to do it now. Let's just see if we can hop on to this slide right here. I just want to, this one. And the reason why I want to talk about this is because if everybody can see that, okay. If this is a timeline, so hopefully you can see the timeline. Now we're talking about historical abuse, and this is why it's so challenging for a lot of insurance policies to respond. A typical insurance policy is what we call occurrence-based. And what that means is, if in the allegations of the statement of claim, it says that on July 4th, 1999, or in this case, let's see, the allegations were July 4th, 1999, and they're asking for $3 million in damages. Well, that's pretty crazy, because back then a typical CGL or general liability policy was $1 million. Because back then, if everybody remembers Austin Powers, $1 million was a lot of money, right? Now we know that's not even, you can't even buy a starter home in Vancouver for $1 million. So, or in much of Canada. So $1 million isn't what it used to be. But the claims that are coming in and the allegations in the statement of claim are asking for more like $3 and $5 million in damages in the allegations. So if you go back to your policy that you had in 1999, and I hope you've held on to your insurance record so that you know who you were insured with back then you can go back there. But chances are that policy is only going to be $1 million, maybe $2 if you had, if you had really good coverage back then. For most nonprofits, I would say $1 million is pretty commonplace. Sarah, you might even know better than I would about the policies that were back then. Like typically they were $1 million back then, standard CGL. So this becomes really important for that timeline. If we're looking at an occurrence-based policy and they're saying that it occurred in 1999, then we need to look at what coverage we had back then, because a GL policy is occurrence-based. If we look at a claims-made policy, on the other hand, right, now we're buying a policy that's $15 million, right? And the difference between a claims-made policy versus occurrence-based is that the date of loss is the date that you're served, regardless of what they say when it happened, right? So it sounds, and for those people who aren't in insurance, for me, it blows my mind. But for you people, you might think, well, that's not a big deal. But it has a huge impact, because the date of loss determines what policy is going to be triggered. So if you go back to that workflow that I showed you before, where we need to determine which policy is going to respond, this is exactly what I'm talking about. Is your insurance company is going to say, okay, but they're alleging that the loss happened in 1999, and we didn't have coverage back then, and so it wouldn't respond if you had an occurrence-based policy. But if you have a claims-made policy with the right retroactive period, where the dates go back in time, they reach back in time and say, this policy will respond. And as you see here, it's going to be a $15 million policy, which is good because it's responding to claims that are being made today, not back in 1999. This policy is going to be adequate for any claims, but we have to be careful that that retroactive date reaches back in time and says, this policy is going to respond to any claim that's made from this period forward. That's the way that works. And I can show you here in this case, if it goes back, like if the allegations were made in 2022, then it reaches back in time. Now, the other thing that happens with these policies that you should be aware of is that the defense costs sometimes go into the limit. So they do operate a little bit differently, but just ask your broker, or you can talk to Sarah at the end of this about whether it's a claims-made policy or an occurrence-based policy that you have. So it's important that we understand our historical documentation. How is it stored? How is it indexed? Is it encrypted? And those kind of things. And that includes your insurance information, because I can tell you, so often we'll get a phone call. It'll be an entity that's been sued for historical sexual abuse. And we were getting lots of calls when that decision was first made saying, did I have coverage back then with you guys? Because nobody could find the policies because people aren't holding on to their insurance documentation. When that decision was rendered, when it changed and sexual abuse became historical, it changed the landscape. I can assure you it sent a lot of ripples through the industry. And as far as like getting phone calls saying, was I insured with you back then? I've got a couple of questions I just want to, so great question. So the question is, you might have already answered this, but I might have missed it. What's the statute of limitations for abuse claims? If it's sexual abuse, there is no limitation. And remember, plaintiff counsel is always going to try to unlock the door to go back in history. That's what they want to do. So even if they're just alleging sexual abuse, even if it was more an anguish or physical abuse, they're going to try to allege that in the allegation so that they can open the door. I believe that even though it was specific to sexual abuse, it opened the door for all sorts of different types of abuse. But typically before then, it was 2 years. So you'd have 2 years from the date of the incident or the date of discovery. Then it becomes a whole other issue, is like, I didn't realize that this was happening to me, or the age of majority is another one. So it would be 2 years past, let's say, for example, if it's a child and the abuse happened when they were 5, you'd still have to wait 2 years past the age of majority. So you could go back historically even for just a regular abuse claim, but typically the Limitations Act would say 2 years, 3 years in Quebec. But now with the sexual abuse being opened up, it's just take everyone. Like there are none. Now, doesn't mean that defense counsel isn't going to ask why did you wait so long, and they're not going to attack that and say, you waited too long for this, et cetera, et cetera. It's not going to bar the claim the way it used to, though. I hope that answers your question. But so for the most part, and there may be some provincial variations on that theme, such as Quebec, but for the most part, there are no limitations when it comes to sexual abuse. The next question is a difference in price between occurrence-based and claims-based policies. It depends is my favorite insurance answer, and I'm sorry, it's kind of hollow, but it really, there is no, oh, this is a 30% more. It really depends on what insurance you've had in place in the past, what are your exposures, what were your exposures back then, et cetera, et cetera. It may be, depending on the insurance marketplace at the time, that an occurrence-based policy is the only one that you're going to be able to purchase. You might not be able to get occurrence-based coverage. Abuse is not an easy rodeo. Like it's not. It's difficult. It's challenging, and hence me being here today. But what I'd suggest is, if you're interested in that, you can always reach out to us or your broker and talk about the difference. But just recognize that especially if you're going from occurrence-based to claims-made, that you have to be cautious about gaps in coverage. What we don't want to see is like 2 years where you didn't have any coverage, because you got to know Murphy's Law still applies here, reigns supreme. That's when the claim is going to happen, is those 2 years where you didn't have any coverage. So just be mindful of that. Don't rely on others. And this is important for partnerships, and we're going to talk about mergers in a minute, but don't rely on others to hold on to documentation. And remember when I talked to you about that historic, if I go back to, let's just see if it'll let me do this, because I'm getting all tricky with my tech here. If we go back to this claims made policy again, one thing that can happen, depending on the wordings in the policy, is it could be, and in most cases this is the case, where sexual abuse spans 5 years. So you may have multiple policies that might respond, which is fine if you've always been with, Frank Cowan Company for those 5 years, then that's fine. You might have a stacking of limits. So instead of just having that $1 million CGL, you could have $5 million if it spans over the case of 5 years. It depends on the wordings of the policy, but you're also going to have multiple deductibles. So just don't forget that piece as well. Okay, so important that we understand that piece. And then you also have to be mindful of privacy compliance, right? So we're going to have, in some cases, depending on what your exposure is, you might have FIPA compliance that you have to be mindful of, et cetera, et cetera. So you have to make sure that you're complying, and Imagine Canada is excellent for this, making sure that you're complying with all of the different legislation that applies to your organization. Because holding on to records for more than the recommended, in some cases 7 years, for example, can be problematic. But if there's a problem that you know of, if an incident has occurred, you may be able to accept that knowledge or that documentation and keep it safely stored in a different area. I do want to go back to one little piece that I forgot to mention because I wasn't reading my notes, and that is this. There's a reason for getting legal counsel on right away. And the reason why is because if we get legal counsel on it right away, the documentation that's kind of promulgated from the investigation or that's discovered can be privileged. Now, I'm not a lawyer, again, don't play one on TV, but the idea of privileging information means that it's behind a firewall that nobody's allowed to see. And that's super important from a defense perspective, to be able to say, sorry, that documentation is privileged, because and counsel can advise you on that privilege. So it's not always a good thing to just say, let's just wait this out and see how things are going to go. Sometimes it's best to get counsel in front of it, and then they can determine whether the documentation that you're storing is going to be privileged. Okay, so I'm getting to the end, and we haven't had too many questions. So if anybody does have any questions, now is the time to type them in that question box. But yeah, just be mindful of privacy compliance. And then I wanted to talk about areas to be of concern that you should be aware of, and that's mergers and acquisitions as well as partnership agreements. If you're partnering with somebody, you need to be mindful of that agreement. Make sure that your lawyer is looking at that agreement, and as well as, you know, at IPE, we have paralegals on staff to be able to tell, and our underwriters will be able to look at that and say, no, by this partnership agreement, we could be taking on historical abuse cases that we just don't want. And so we need to make sure that we're plugging that hole. We don't want, just because you're getting into a partnership with another entity, that you're actually taking on those liabilities. And that should be found. And so often, and we're all on shoestring budgets here, especially nonprofit organizations, that's why we have to be so mindful when we're getting into those, even those ad hoc partnerships where maybe you're putting on a special event, but then you're going to partner with I'm not going to name names, but say a local community group or whatever, because they've got a trampoline or a bouncy castle that they can use, like whatever that might be. Just be really cautious about those partnership agreements, because nothing's going to stop the plaintiff counsel from bringing you on to an action just because they feel like they're kind of tapping into those deep pockets. So it's important to understand with a merger agreement or a partnership agreement that you are protected, that your best interests of your entity are being protected. Your security of your records management, I often see this really fall down, not just in nonprofits, frankly, with everyone, especially because when we're going back in those historical cases, I can tell you, like it used to be, even at Frank Cowan Company, which is the name of our old company, what IPE used to be, we had a vault full of, remember this, Sarah, down in the basement, right? We just had bankers boxes full of documentation, which comes in handy when the internet is down. But and if you're Luddite like me, I love paper, but it can be really like you have to be really cautious, because who's in a partnership, for example, who's taking over those bankers boxes? Who's taking over that documentation? Sorry, you're going to say something.
Yeah, no, I just, going back to your story about record keeping, you know, working on the underwriting side, I remember pulling out those boxes and looking through paper files to try to find old liability policies.
Absolutely.
That insureds were looking for to find their coverage. So
absolutely. Like when that opened up in 2016, the job that I had was fielding claims and dealing with Frank Cowan Company. And I was phoning Kristen, our genius in the claims department, saying, do we have this policy from 1999? And she would go back into the vault and see if it was there, to see if there was a policy that would apply. So just be mindful of the data that you have in historical records. Where is it now? Has it been scanned? Has it been stored? Is it encrypted? Are you going to be able to access that information? There's almost nothing more frustrating than knowing that you kept the documentation from 2001, and that's when the claim occurred, but you can't find it, right? And now all of a sudden, we've got claims adjusters or information specialists that are going back in your documents trying to find it, and that can be really problematic. So just make really careful about the record management. The other thing that we need to think about is websites and deep fakes, right? We've now, the EU or the UK has just passed a law about deep fakes, and from a woman's perspective, that's awesome. But and you might think from a nonprofit perspective, yeah, but that's okay because we don't do that kind of stuff. But if you're enabling it, if you're a library or a school that's providing the ability for students to do that, you could be implicated in a claim. I do have a couple questions here, so I wanted to just field them if I can. Are students, student placements, and the nonprofit posts from colleges and universities, do they fall under the nonprofit's liability, or does this fall under the respective colleges or universities? That is an excellent question, and one that we field all the time in our risk management department. And again, my hollow insurance answer, it depends. It really depends on the agreement, because you should have a co-op agreement with the placement school. And we need to be really mindful of, if we're bringing on co-op students, which are, in my opinion, are ostensibly volunteers, but if we're doing it on the behest of a school or a college, do we have an overarching agreement? I've seen one where where if it's like medical malpractice, where they're doing things like long-term care for in a geriatric home or what have you, it's very specific over any kind of pseudo medical treatments that are being done might be handled by this policy, whereas the actual teaching or what have you might be done by this policy. And so it's a great question, and it needs to be broken up within the agreement that you have with the placement agency or the school that you're in place. So I hope that answers your question. My great it depends answer. Does vicarious liability apply to directors and officers as well? Yes, right. So we need to be very mindful that on top of everything that we have a good D&O policy in place, because their actions, first of all, there's all sorts of different reasons to have a really robust D&O policy in place. And we're going to have, I think we have a session on that as well. But the Ds and the Os need to be protected. And we see this in municipal insurance all the time, where we need to make sure that the elected officials are protected by liability policies, because they're often brought into abuse, implicated in abuse claims as well. So absolutely, that needs to be taken into consideration. What we'd like to see is a D&O policy that marries with your abuse policy, so that it's like this and there's no gap. So what you need to be mindful there is that you might have different carriers. And if you've got different carriers instead of kind of an umbrella policy, just to be mindful of those gaps. Sorry, I just want to make sure that I've answered all the questions. Yes, okay, so far I've answered all the questions, and we've got 6 minutes left, so we're doing great. So when you're talking about the agreements that we're entering into, a lot of the times, and I'm sure, and Sarah confirmed this before this session, is you're being asked a lot of the times, you're either asking or you're being asked to be added as an additional insured. And so this is super important, and for those of you who haven't really gargled in the insurance Kool-Aid, we need to understand why that matters. It's part of a hold harmless language. So if you're partnering with somebody and you're signing the formal agreement, it might say, you know, your entity agrees to hold this entity harmless. Typically what we see is an organization, let's say like somebody very large and nationwide, might be partnering with a smaller community-based group, and this larger entity is going to say, you're going to hold us harmless in case something happens, right? If it's just for the purposes of renting out a bouncy castle for the day, maybe that's not going to be a big deal. But basically it means if any claim emanates that's due specifically to this, this arrangement, that this smaller entity is going to be responsible. But it is an important thing to think about, because, you know, basically, and I think I've got it on here, it gives you would you give the keys to your new Mercedes to your son's best friend? This is the question I always ask when I'm talking about additional insured, because ostensibly you're giving them the keys to the kingdom. You're saying, we're going to insure you for this. We are adding you as an additional insured onto our policy, so that you don't have to have insurance for this. Now, chances are they may have their own existing insurance policy, and there are a host of arrangements where this happens. A lot of the times what we see is nonprofits being brought into a municipal policy saying, we want to be an additional insured on your policy, which is fine. That's a conscious arrangement of risk transfer, and it needs to be thought through. But at the end of the day, again, ask yourself this question next time you're being asked or to add somebody onto your policy. Would you give them the keys to your new Mercedes? Because if you don't know them, if you don't know how they manage their organization, whether they comply with Imagine Canada's standards, et cetera, if they don't pass muster in that regard, they shouldn't be added onto their policy, because you're now taking on the weakest link that you have in your chain of defense, in your armor of defense. You need to focus on the agreement that you're entering into. What's the scope of that agreement? If it's just you're renting out a bouncy castle for a special event, that's the scope. It should have dates and firm times and time limits on it. That's super important. It shouldn't just be forever and a day. And again, their due diligence. Are they complying with Imagine Canada standards? Really super important. And what is their best practice? Perhaps even in some cases, if possible, they will exceed the Imagine Canada standards. And that should be noted, especially when it comes to things like, how do you deal with incidents? How do you deal with complaints? How do you deal with abuse? Especially if you're, especially when you're dealing with children, how do you deal with that? Do you do the same criminal record checks that we do, et cetera, et cetera? If you're holding those standards in place, then you can feel a little more confident bringing them onto your policy as an additional insured. And conversely, if you're being asked to be added to somebody else, don't be surprised when they ask you those questions, because they should. They're giving you the keys to their Mercedes, and so they need to be mindful of what they're doing. It can't just be, yeah, we'll add you as an additional insured, or it shouldn't be, right? Because then you may not be getting the protection that you really want, because perhaps this entity isn't as careful as they should be. So with that, I finished my content. I hope that answers any questions that you may have, or kind of has opened up the why behind the important compliance guidelines that Imagine Canada has structured for you. I hope if you have more questions, because I have a couple minutes to answer them if you do. But Sarah, if you want to, I don't see any more coming in. So Sarah, if you want to take over from here, or Tim, if you have anything you'd like to add.
Thanks again, Tracy. I always love to hear your talks, and your sessions are so informative. I appreciate it. And to the team at Imagine Canada, again, thanks for having us here. We're very excited to be doing these sessions alongside you. If you have any questions about the sessions, or are interested in learning more about how you can benefit from your Imagine Canada accreditation status with IPE, please don't hesitate to reach out. On the screen and attached, there's a little
sorry, my bad.
Paper clip. That's okay. There's a paper clip up there too, top right-hand corner. There's information about our next sessions. Our next one on May 7th, Tracy mentioned, will be co-hosted with Jessie Lee Wallace.
Great.
Yes, from Volunteer Ottawa. I'm super excited about that one. Very important topic about managing your volunteer workforce. We hope to see you again soon. And
before we go, I did have a question come in, and it's one I wasn't going to field it, but I think I will, if that's okay. And it says here, what's the most surprising abuse claim you've seen in recent time related to NGOs? And I'm not going to say it's surprising, because that's kind of glib, and but I can tell you that I've fielded a lot of these statements of claim, and I just as a closing kind of sentiment, I want to just say that, reiterate what I said before. Abuse claims are not surprise, like it's shocking. Like, they're never not shocking. They're never not heartbreaking. Even though, you know, I mean, I love kids, and especially when they involve children. I know oftentimes I would go home shaken because of what I've read on a statement of claim. And the reason I want to bring that up, and in response to this question, is to remind you all, when you receive that notice letter, when you receive that statement of claim, it will be inflammatory. It is meant to repulse you. And so, you know, foster care is something that you know, that I've seen some really terrible ones in, but I've seen them in, you know, I've seen church ones. I've seen all measure of, and I don't want to see any more because they're terrible. But I did want to just reiterate that really important point, because it's really important when you receive that notice letter or that statement of claim, no matter how inflammatory it is, you have to deal with it in compliance with the standards that Imagine Canada has provided, because they're right. That's what you want to do, and they're there for a reason. So sorry, I can't really give you a long sob story tale about, you know, one particular one or one really shocking one, because they're all shocking. They're all terrible, because, you know, typically they involve children. But just that there's a lesson behind that, and that is, we have to act the same. We have to act consistently in compliance with standards when we receive notice, statement of claim, or even a whisper of those types of claims. We have to respond proactively, professionally, within the guidelines provided. Super, super, super important. So there's my big lesson of the day. Sorry, Sarah, I didn't mean to interrupt, but the question came in. I wanted to field it.
Tracy, and you know, I would add to that, don't even think I'd want to repeat some of the claims that we've seen, unfortunately. And on that note,
on that happy note,
I'm going to pass it back over to Tim for any closing remarks, and thank you again.
Yeah, one more piece on that is, I think, in the spirit of accreditation is is non-reactive creation of policy and processes. So having this list of things that, why would we do this, and then realizing later why you have it. I think that's super important, is that you just never know what's going to happen as long as you have volunteers or staff or do any activities at all. There's just so many unknowns in that, and often organizations wait until we see, especially with things like succession plans, we see people kind of waiting until they need one to make one, and then suddenly you're making one when your head's on fire. You're trying to deal with not having this ED that kind of knew everything in their head, and then that's when you're writing a policy, which is the worst time to do it. So the best time to write a policy is when it seems totally irrelevant, ironically. Yeah, so I really appreciate that really engaging presentation. I thought that was really valuable, and I really appreciate how you conveyed those pieces. I think I'm going to remember the phrase "gargled the insurance Kool-Aid." Is that a phrase you used at one point? I don't know if you've said that before, but I feel like that might be the first time that phrase has been uttered. Definitely heard by me. Yeah, I appreciate that. Some sort of
tasty.
We like
yes.
it.
Yeah, we like it. Yeah.
I will try some point. But yeah, thank you so much. This was really, really engaging, and I'm looking forward to the next few sessions, which yeah, cover some really important.
I'm really excited about the volunteer one, and Jessie Lee is going to be amazing. You won't have to listen to my voice drone on for the whole time. So Jessie Lee's amazing, and I'm really excited about it. So I'll see you. Hopefully, I'll see you then, and I'll hopefully see everyone in the group.
Take care, everyone.
Thanks everyone. Take care. Bye.
Bye.